Welcome back to the ABCs of environmental law. Today, A is for allocation, which really goes to the heart of one of the most common questions we get, which is, who's going to pay for this? Environmental contamination is generally a strict liability issue, and that means fault often doesn't matter. If you're a current property owner or business operator, or you fall into certain historical categories, you could be held fully responsible for investigation and cleanup, even if you didn't cause the pollution. Now, in practice, agencies usually want one responsible party to step up and get the work done. And from a regulatory standpoint, it means the focus is on cleanup first, sorting out fairness later. That's where allocation can come in. Allocation is the process of arguing that cleanup costs should be divided amongst multiple responsible parties. And that's based on factors like timing, degree of contribution, control over the site, and conceptually, it sounds fair, and sometimes it is. But there is a reality, which is that allocation does not automatically kick in to avoid the cost of cleanup obligations in California. State agencies are generally not in the business of mediating these cost-sharing disputes. So if you're a responsible party, you're on the hook, and the agency may take the position that they don't have to decide what percent responsible you are compared to someone else. They know where to find you, you do it. But where allocation can matter is under federal law. And in federal cases, courts may allocate costs amongst responsible parties even after a cleanup is underway. The key takeaway is this: allocation is about cost recovery, not avoiding cleanup. Understanding that distinction helps set realistic expectations and smarter strategies from the outset, and helps everybody to understand exactly where they may stand.